Ladies and gentlemen, please welcome my good friend and colleague, Representative Bob Lewis.
Well, the topic today was advertised as human trafficking, and that is a broad topic. And I'm going to focus my comments on three areas of human trafficking, sex trafficking, that I know most about because that's the area I've been working on. Child sex abuse, child pornography, or what we now call child sex abuse material, which I'll explain later, and although I'll also make some comments about Epstein. But before I get to those topics, I really want to thank Jim for that very nice introduction. Jim didn't really get into how we know each other, but I can tell you that he has been very important for my job as the head of the corrections committee. Last year, about this time, the speaker told me that I was going to chair this committee, the Corrections and Juvenile Justice Committee, and I was thrilled to do that. And I have worked in criminal justice in various ways over the last 38 years. But quite frankly, I knew very little about juvenile justice, and even less about juvenile justice in Kansas. And so I was quite pleased when Jim called me out of the blue before the session started and told me that he was putting together a meeting of about 15 people here in Wichita, actually in this building, and that he invited me to come. And of course I agreed immediately because I needed to know what I was getting myself into. And I attended that meeting. There were judges, prosecutors, social workers, other colleagues of mine in the House and the Senate that were working in this area, including Cindy Howerton, who is the chair, or was going to be the chair of the child welfare group. In that meeting, I listened because, as I said, I really didn't know much about anything that was being talked about. But what I did learn was that we had reformed the Juvenile Justice Code in 2016, and that those were good and necessary changes, but they needed to be reworked. And with the help of Jim, we started and did that in the House this last year. I said to Jim afterwards, I said, look, Jim, you seem to know more about this than certainly I do. So if you want to draft the legislation, I'll see to it that it gets passed. And so we did exactly that. He drafted it. He brought it to me. We had 2 hearings in my committee, and Cindy Howerton had a hearing in her child welfare committee. And despite initial skepticism by Democrats on the committee, we ended up passing it out of the Corrections and Juvenile Justice Committee with unanimity. That included, for instance, John Carmichael, as well as the ranking. I was thrilled by that. We went to the House floor and we ended up with, I think, 216 votes, and it's now, as Jim has indicated, it's now in the Senate, and we're hoping to get that passed. It will, I think, advance the cause of juvenile justice in the state by, one, giving judges more tools that they need to hold juveniles to account, and taking the problem juveniles that are now corrupting our foster care system and our schools out of those and putting them into group homes. So once again, I really appreciate Jim for helping me in my maiden voyage as the chair of that committee. I also want to thank you all for inviting me to talk today, but I've been to these meetings several times, and I'm always so impressed at how you bring ideas to the fore and discuss them and sometimes debate them, and then how active all of you are in the political process. And it's actually thanks to you and people like you around the state that we have now functional supermajorities in both chambers of the State House, and we occupy all but one elected statewide executive position in the state. And I'm confident that if we stick together in 2027, we will occupy the second floor of the Capitol as well. Also want to thank you for sending just a fabulous delegation from Wichita, Sedgwick County, Butler County, this area, to the State House. To a person, I enjoy working with them. They're team players, they're leaders. They bring variety of experiences to the table, and it's just a thrill to work with Leah and Leo, and I think that's the only, oh, Emil, there, you snuck in. But it's just a joy to work with all those folks, and of course you now have the leaders of both the House and the Senate from this area, and so thank you so much for that. So, functional supermajority. Just before I get into my topic, I have to comment that we do have that, and we've used that to great effect in the last session. The three accomplishments I'm most proud of because of this functional supermajority we have is, number one, that we passed a bill over the governor's veto that protected kids from ideologically driven mutilation of their bodies in a futile attempt to change their gender. That was number one. Number two, we passed a bill that I think will begin to move us towards a 4% flat income tax rate. It didn't get a lot of press, but I think that's one of the most significant bills we passed in the last session, and once again we passed it over the governor's veto. In all, we overrode her veto on 15 full bills and 14 light item vetoes. And that's, once again, thanks to many of you around the table. And then the final thing that we did, and this didn't require overriding a veto, but it did require 2/3 majorities. And we had to work very hard to get those, but we ended up getting them. And that's the judicial selection amendment that you will see on the ballot in August of 2026. So many people worked hard to get that passed. The morning that we were to vote on that in the House, I still remember the speaker coming into our caucus before and telling us that he had just gotten a call from the White House, and that it's the first time that had ever happened with respect to legislation. And we were still twisting arms in that morning, but we finally got it over. I'm very passionate about this. One of the op-eds that you have on your table is one that I wrote recently for the Kansas City Star. It basically examines the commission, which is now the system we use to select our Supreme Court justices, and explains how the recent work of that commission was, number one, certainly not merit-based, which the proponents all say that it is, and certainly it wasn't apolitical. In fact, they clearly did not pick the most qualified candidate, and the candidate that they did pick was purely political. As I said, I'm passionate about that, and I would welcome an opportunity, quite frankly, to come back as the date approaches in August and speak further on that. I will be going around the state as to promote that, because in my view that is arguably a more important election referendum, quite frankly, than the gubernatorial race, although that's critically important. But changing the way we select our Supreme Court justice is going to have long-term effects on the future of this state. So how did I get involved in child sex abuse cases? As I say, as Jim mentioned, I'm a lawyer. I've been practicing for about 38 years. In the early 1980s, therefore, I was in law school. And I was at Stanford Law School, and I say that because, as you probably are right to presume, there were not a lot of conservative either professors or students. But we did find each other, and I still remember to this day sitting at dinner with my conservative colleagues, my conservative fellow student classmates, and we would talk about the fact that, so often in our classes we were talking about the downtrodden in society and how we could help the downtrodden to, raise them up and make society more fair and so forth and so on. But there was a conspicuous absence of any talk in our criminal law or our criminal procedure classes about the victims of the crimes. We constantly talked about the rights of the defendants, which is important, but we completely ignored the victims. And that struck me as odd at the time. And then 10 years later, in the early 90s, I was a federal prosecutor in Los Angeles. And there again, I was struck by the fact that the victims of the crimes that we were prosecuting really were afterthoughts. We would talk to them when they were necessary as witnesses, perhaps, but there was very little outreach to them to help them to overcome whatever traumas they might have suffered because of the crime that they were the victim of. There was no talk of giving them notice or talking to them about any plea deals that we may be cutting with the prosecutors. There was no sense of having them into the sentencing proceedings to talk about what the crimes had done to them. So, the mom who's raped coming home at night or in the early morning after cleaning the offices of people who make a lot more money than she, and she's raped and yeah, it gets prosecuted, but where is she? Where is that victim in the process? And it just struck me as odd that wasn't being considered in our criminal justice system. So it also is the case that basically about in the 1990s, there was a movement, a criminal victim rights movement, which started in the country and grew. And states and the federal government began to pass criminal victim rights laws. One of the most important was a 2004 law that was passed as the Criminal Victim Rights Act in Congress, and it does the following. It gives the right to the victim to notice of court hearing dates, to attend court hearings. It gives them a right to be heard at the appropriate time, which would normally be at the sentencing phase. It gives them the right to have the process proceed without unreasonable delays, to give notice of the release or escape of the defendant so that they can be protected, the right to privacy and dignity in the process, which was, in my experience, often ignored, and the right to restitution in appropriate cases. So that all happened in 2004. After leaving the prosecutor's office in California, I returned to New York, where I'd been before. I was working in basically commercial litigation arena. It was interesting. It was remunerative, but it wasn't my passion. And I went to a reunion at law school about that time, late 2000s, 2008, 2009. And I ran into a colleague of mine from law school, Paul Cassell. Well, Paul was the star of our class. He was president of the Law Review. He and I worked, I was a notes editor. We worked together in that. And he went on to clerk for Judge Scalia before Judge Scalia became a Supreme Court Justice. Then he clerked for Supreme Court Justice Berger. He went on to be an assistant U.S. attorney in Eastern District of Virginia, and then he ended up as a penal law professor in the University of Utah. And his passion, his focus was on criminal victim rights and bringing that into the to the law school curriculum. And so Paul also, interestingly enough, at an age of like 39, became a federal district court judge. And what was interesting, he left his professorship to do that, and 7 years later, he woke up one morning and he said, this is kind of fun and interesting, but it's not my passion. My passion is criminal victim rights. And so he left the bench, returned to his professorship at the University of Utah, and has been on the forefront. So I ran into him at the reunion, and he started talking about some of the work he was doing in the child pornography arena. Now, as I said, we now call that child sex abuse materials, or for short, CSAM. And that's because when you say child pornography, it suggests to you that the child is somehow consenting to this, and that they're consenting to the production of this smut. And that certainly legally cannot be the case if they're not 18, and it's practically also not the case. So that's why people in this arena are now using the term child sex abuse material, and I'll use that throughout, referring to it simply as CSAM. So Paul, working with a lawyer in New York, James Marsh, they were representing children, oftentimes by then adults, who had been used to produce the CSAM. And what they were doing is they were going into federal criminal proceedings where typically there was a defendant who was caught with possessing troves of child pornography, CSAM. And some of those images turned out to be images of our clients. And the way that happens is there is a group in Virginia. It's called the NCMEC, which is National Center for Exploited and Missing Children. And that's a clearinghouse for images of CSAM where they know who the victims are. And so if there's a takedown of someone possessing child pornography or CSAM, typically it's thousands of images. That's just the typical situation. The FBI or whoever the authority will send those copies of those images to NCMEC, and NCMEC will then match them with the victim. And then the victim, if he or she has a lawyer or otherwise, will get notice that Joe Smith has been arrested in Kansas and is going to be prosecuted in the district court here, and you have an opportunity to go in and seek restitution. And that's what they were doing. So let me give you one example of one of their clients, which ended up in the Supreme Court. Her pseudonym was Amy. Amy, at the ages of 8 through 10, was being raped repeatedly by an uncle that lived down the street. The uncle was found out. He was prosecuted. Amy, of course, had trauma and difficulties because of that, but life went on. But then, when she was in her mid-20s, she became aware that the uncle had taken pictures of the rape. And those images were now circulating internationally on the internet. And it's the case that almost daily, our office was getting notices from NCMEC of someone else who had been arrested with her images on their computer. So, as I said, we would go in and seek restitution in the sentencing phase of those federal criminal prosecutions. But the law was, quite frankly, a little bit unclear on exactly how judges were supposed to figure out how much restitution was to be given to these victims. And so we teed up the case, an Amy case, out of a district court in Texas that went up to the Fifth Circuit. And eventually we got it into the Supreme Court. The court granted cert, which anybody who's aware of Supreme Court practice knows that's actually almost the bigger trick than getting your case, winning your case, is to get the Supreme Court to hear the case. But the Supreme Court did. And so we did Paul Cassell was working the case. He ended up arguing it. I, of course, worked on the brief. But there were three things that came out of that case that are important. First of all, we as the victim, the victim of this crime, representing the victim, were given equal standing in the arguments before the Supreme Court. I mean, remember, this is a criminal case, so typically you have the government versus the defendant, but the victim's mostly ignored. But in this case, we were given equal standing. Paul was given equal time to argue his case in the court, and that was really, as far as we know, the first time that had occurred in the Supreme Court. So we were pleased by that. The second thing that happened is the court said clearly that, well, one of the arguments that the defendants in these cases were making was, hey, no harm here. Amy didn't know that I possessed her images, so what's the big deal? I mean, it's just private. And the court said, no, that's not right. The court said, no, anytime someone else looks at the images of a victim of child sex abuse, they are invading her privacy and her dignity. And she is harmed even if she doesn't know that that particular defendant is looking at those images. It's like if somebody in another room was talking bad about me and they were making false statements about me and I didn't even know it. I'm still harmed. It's like a defamation case. So that was an important part of the Supreme Court decision. The second thing that they said was, people say, oh, it's just possession. What's the big deal? It's the distribution and production that's more important. And the court said, no, the possessors are the market. If you didn't have a market, you wouldn't have the production and distribution. So they clearly said that this was a serious crime that needed to be taken seriously. The opinion that actually came out, it was a mixed bag in the sense of, but as I said, the law was really a little bit unclear. And so they gave us different factors that we were supposed to go back to the trial courts and ask them to take into account in the restitution process. But they also told us, and this was all of the justices in the various opinions, they said, really, this is an issue that has to be taken up in Congress and has to be resolved more clearly there. And that's what we did. We went back and with mainly senatorial support, both the Democrats and Republicans, Feinstein was one of the senators, we got the law clarified, and we're now going into court all around the country, continue to use the law that we got passed in a few years back. I have 3 cases now in the Kansas federal court here on the issue. So that's what I'll just make one more comment. It's a big problem. The producers and the distributors, unfortunately, are often overseas, so they're difficult to snare, and that's why prosecuting the possessors is so important. And I'd also say the research shows that those who possess the CSAM not infrequently end up physically actually abusing then kids, and they also use those images to groom the kids and make the abuse seem normal. So it has a lot of dilatory effects. And of course, before the internet, this was, if you wanted to possess this stuff, you had to go in a back alley and find somebody. That was difficult. But today on the internet and the dark web, it's very easy to find this stuff if you want to. So that's the CSAM issue. One interesting thing we did in the last session of the legislature with the help of a young representative who has been working in this field as a law enforcement officer is we passed a law that criminalizes the creation of CSAM using AI. So there you don't have a victim. That's the key, But nonetheless, we passed that law, and the governor signed it. So once again, it's used to groom the kids, and there are all sorts of problems with it. It's not a victimless crime. Now let me talk about what I'll call hands-on physical sexual abuse. And I'm going to focus in particular on what I'll call institutional complicity. Sex abuse of children, as I think I'm sure has existed since Homo sapiens began walking the face of the earth. It was mostly ignored over the centuries. Children are vulnerable and powerless. They don't understand how wrong it is, and even if they do, the shame and the fear that they will disrupt the family or cause harm to a trusted perpetrator makes disclosure very difficult. I remember talking to a client of mine who had been abused by a Catholic priest, and it came up as to why he didn't disclose that as a child. And he said to me, well, first of all was the shame, but he said, even if I could overcome that, I was in a dilemma because I would either not be believed, okay, and then punished, or if I was believed, my father would kill the priest. So, I mean, put yourself in the shoes of a 10-year-old and tell me that there's going to be disclosure. Simply not going to happen. The problem, I think, came to the broad public's attention in the United States in the early 2000s. Some of you may or may not, or you may remember that it was in 2002 that the Boston Globe did an investigation of the abuse by priests in the Boston Diocese of children. And they ended up, I think, convicting 5 or 6 priests, and as the story grew, it became, clear that this was really endemic. Initially, I think people thought that this was an isolated circumstance in that particular diocese, but soon it became clear that no, this was a problem throughout the Catholic Church, not only in the United States, but worldwide. The pattern was pretty straightforward. A priest would get caught. They would send him, I think, to Georgia. They had a sort of a re-indoctrination camp. The priest would spend a few weeks or a few months there, and then what would they do? They'd send him back to work with children. And not only would they send him back to work with children, but as punishment, okay, they would send them into poor parishes. Now, what does that mean? It means they're going to be around more vulnerable kids without parents, for instance, and kids that therefore were easier for them to prey on. So in trying to resolve the situation, they ultimately just made it worse. So what happened in Kansas? As I said, it became clear this wasn't unique to the Boston Diocese, and in the mid-2010s, the KBI began investigating the diocese in Kansas. And it took them 4 years. They didn't have subpoena power. They found that many of the priests weren't cooperating. But nonetheless, they interviewed a lot of the victims, and they then wrote a report which came out in December of 2022, just before I was to begin my service in Topeka. They found that, as I said, they identified 40 victims and identified 188 clergy here in Kansas that were likely perpetrators. So you ask what then happened as a result of that report? Well, not much, because of statute of limitations. At that time, the statute of limitations for criminal prosecution was 10 years, and for civil actions being brought against the perpetrator or the institutions that enabled them, it was a statute of limitations that ran to the 21st birthday of the victim, or the survivor, as I prefer to call them. That the idea was you reach majority at 18, you have 3 years. Typically, that's the statute of limitations for torts that are committed against kids. But the problem was and is that this is a different situation because of the problems having to do with disclosure, as I mentioned. The research has shown that people who are abused as children typically, on average, do not disclose until they're in their early 50s. So consequently, virtually no one is disclosing and therefore bringing a lawsuit before they're 21, or even going to the police in the 10 years following the crime. So as a result of that investigation, nobody went to prison. There were no civil lawsuits that were able to be brought. It was all for naught. So as I said, that was just before I started my service. And throughout the state, the country, the movement was already going on to extend statutes of limitations. And so in my first session, I worked with, quite frankly, across the aisle, because that's where I found people most interested in the issue. And we managed to get some reform in Kansas. We eliminated the statute of limitations for criminal prosecution, which is obviously good. But unfortunately, we were only able to get the statute of limitations for civil actions to the age of 31. And as I said, if the average age of disclosure is 52, there's not going to do a lot of good. And indeed, in the last couple of years since the statute has been passed, I'm only aware of one civil case that's been brought that would not have been brought before the change in the law. So I'm continuing to work on that in the next session, and will continue my efforts in that regard. More legislation is needed. And the other issue that needs to be addressed, and there's a bill that actually passed the House session before last and a bill that's now in the Judiciary Committee, has to do with mandatory reporting of child sex abuse. This is basically the law that says that if you are a professional and you hear about an allegation of child sex abuse, you are by statute required to report that to law enforcement. Kansas has a law that has a laundry list of mandatory reporters, whether they're EMS, law enforcement, social workers, healthcare workers, so forth and so on. But there's a conspicuous absence from that list, and that is clergy. Yeah, clergy. So we're working to add clergy to the mandatory reporting list. Finally, let me address something that's sort of hornet's nest, and you know, you hear every day something more about the Epstein case. I have worked on the Epstein matter for the last 10 years, and I'm not going to sit here and just go over all that you've been reading in the press. There's a long history, lots written on it. I've represented and continue to represent a number of victims as well as witnesses in the matter. I sat through the Ghislaine Maxwell trial, and I had two clients that testified at her sentencing. It's a long history with lots written, but many lingering questions, such as how far-reaching was the sex trafficking conspiracy? Was it just Epstein and Maxwell? Who, if anyone, was a willing participant or a customer? Does it reach the highest levels of government in corporate America? Was Epstein a government asset? Was that the reason he got such favored treatment for all those years? Was he blackmailing the Johns either on behalf of the government, for whom he may have been an asset, or to get government favors? Why, after all the promises of full disclosure by the administration, has it clammed up and told us that the case is closed? I think all of these questions are subsumed by an overarching question, which is, why did it take the federal government more than 2 decades from the first known report of Epstein's sex trafficking enterprise to finally indict Epstein in 2019? That is, in fact, the central issue in a case that my firm brought in May of this year against the federal government. Our client, Maria Farmer, went to the FBI in 1996 to report the sex trafficking by Epstein. But the government waited more than 2 decades to indict. Why this abject failure and indefensible failure? Was it just plain negligence and stupidity, or was it more sinister, a failure grounded in political corruption? So, as I said, our case has been filed. It's in the early stages, but let me lay out some of the key allegations in our 63-page complaint made after thorough investigation. First of all, Epstein's shady past. In 1981, Epstein left Bear Stearns, where he's a trader, under suspicious circumstances, suspected of having engaged in security violations. He then became a business partner with Stephen Hoffenberg at Towns Financial. Some of you older folks may recall that Hoffenberg was prosecuted for massive securities fraud. He was found to have bilked investors to the tune of $450 million. He spent 20 years in prison. What happened to Epstein, his partner? Nothing. Epstein was, there was a co-conspirator, and he was co-conspirator, but he didn't get prosecuted, didn't spend any time in prison. He skated. So then, also curious is in 1992, so this was been about that time, the U.S. State Department rented a luxurious New York City townhouse to Epstein. State Department renting to a private citizen? Strange. And then Epstein proceeded to violate the lease by subletting the apartment and taking a profit. The government did bring a lawsuit against him for that, but that lawsuit was quickly resolved documents were sealed, and as far as anyone knows, Epstein walked away with little, if anything, other than a terminated lease. As I said, then in 1996, so 4 years later, Maria informed about the problem to the FBI, and in that conversation, the FBI hung up on her and didn't return her call after that. They did nothing to pursue that lead. In fact, as I said, hung up on her. Then let's fast forward a few more years to 2002. J.P. Morgan reported suspicious financial transactions on at least 6 different occasions involving Epstein, totaling millions of dollars. That was to the U.S. Treasury Department. The government did nothing. About the same time, the Secret Service, also part of Treasury at that point, although they moved with the rejiggering of Homeland Department, they cleared former President Clinton for travel on Epstein's private Lolita Express, the private jet. Now, think about that. The Secret Service is in charge of protecting our presidents and former presidents. They have to do a deep dive if you're going to put the president, former president in this case, on a private jet. It's hard to believe that they didn't, and this was, Epstein was in the heyday of his trafficking in 2000, early 2000. Yet they cleared that, no problem. Then we go to 2005, 2006. That's when a 14-year-old girl and her parents went to the Palm Beach police and told them that she was being sexually abused by Epstein. The Palm Beach police actually took it seriously. They did an investigation, but about a year into that, they realized that the local prosecutors were mishandling the matter and weren't going to pursue it. So they then went to the federal government, the FBI, and gave them the information. The FBI and the U.S. Attorney's Office in Miami investigated, and they identified 30 victims, 20 of whom were 14 to 17-year-olds. But what happened? They ended up not only not indicting him, but rather entering into a highly unusual non-prosecution agreement and sending it back to the locals, where he got a very sweetheart deal and spent little time in prison and was out every day going to his mansion, and it was really ridiculous. The investigation since then has shown that the U.S. Attorney's Office, Mr. Acosta, failed to follow a plethora of regulations and DOJ policies regarding child sex abuse cases. First of all, he failed to inform the Civil Rights Division and the Child Exploitation Obscenity Section, who were the parts of the government that were experienced in these cases. He failed to follow policy and rules to inform them. He failed to consult the victims. As I said, the Crime Victims' Rights Act had been passed. He failed to consult with the victims before entering into the non-prosecution agreement, and that was in violation of that act. And after the non-prosecution agreement was entered and the victims started to ask questions, he lied to them and said that the investigation was continuing when it wasn't. He called in his missives to DOJ later, he called them child prostitutes. And he entered the non-prosecution agreement in violation of several DOJ policies. For instance, it requires that the person obtaining this non-prosecution agreement actually do something to cooperate with the government. Epstein did none of that. Very unusual, it provides immunity not only for Epstein, but for all his unnamed co-conspirators, whoever they might be. And then this, his lawyers are also included in the immunity. It's just crazy. I'm representing somebody and I'm telling the prosecutor, by the way, just put my name in there and make sure that I don't get popped later for the crime that I'm representing my client for. And that included Dershowitz and a whole slew of high-powered lawyers. So the DOJ, as I said, failed to follow policy, and the Office of Professional Responsibility ultimately looked into this, and they concluded likewise that the U.S. Attorney's Office had allowed Epstein, I'm quoting here, to manipulate the conditions of his sentence to his own advantage, that he prematurely resolved the case without obtaining Epstein's computer equipment and taking other investigative steps. He failed to coordinate with the DOJ and lacked coordination with the DOJ. But despite all that, the OPR report concluded that this was just a matter of bad judgment. A senator at the time who read the report said this, and I'm quoting, "Letting a well-connected billionaire get away with child rape and international sex trafficking isn't poor judgment. It is a disgusting failure. Americans ought to be enraged, but the Justice Department failed Epstein's victims at every turn. The DOJ's crooked deal with Epstein effectively shut down the investigation of his child sex trafficking ring and protected co-conspirators in other states. Justice has not been served." Subsequent to that, 2019, the Southern District of New York, to their credit, indicted Epstein, indicted Maxwell, prosecuted her. They did a very, very admirable job. I watched that trial. Very admirable. Just as a side note, Maureen Comey was the head of the sex crimes unit at that time, and she was the lead prosecutor. But despite that, the questions remain. Why did it take the federal government more than 2 decades from the first known report of Epstein's sex trafficking to indict him? Was it, as I said, negligence or something more sinister? The answer to that question awaits the government coming clean in the Maria Farmer litigation, which we brought, or through political pressure in Washington. Until that happens, the cloud hanging over the government's head will not lift. Thank you, and I'm open for questions.
Okay, we'll go ahead and questions. If you have any questions, if you're a member, try to get to you first. We'll start back here.
So you, the attorney, know that part of the problem with
It's on tape.
delayed justice, like giving them 10 years or no time whatsoever, is evidence and witnesses disappear and so forth. So while I think it's admirable that we do what we can to protect these children and go after the perpetrators, what about, some innocent defendants who can't defend themselves because the evidence and the witnesses are gone or not available?
Right, so I appreciate that problem. It's a problem, as you point out, that is at the core of our statute of limitations law. But what I would tell you is that the problem of witnesses and evidence affects both the defendants and the plaintiff. I mean, the plaintiff continues to have the burden of proof in these cases, and if we can't come up with it. For instance, in our institutional, what I call the institutional cases, where we have to prove that the institution had some forewarning that this was going to happen. It's not vicarious liability. That is to say, you can't just prove that the abuse occurred while the child was under the care. You have to prove some forewarning. And that is a problem for the plaintiff. We have to typically find something in their records that will support that. And yes, sometimes those records don't exist. So it's a problem, and I can only tell you my sense of things. It's rare that when people come to us, that they're not being truthful. I will tell you that you may recall there was a big class action against the Boy Scouts, and that was in the bankruptcy process. And as you know, when you're resolving things in bankruptcy, the process is truncated. It's not, and what we found, quite frankly, was that there were a number of people coming forward, because in those processes, to get some compensation, you just don't need it. It's different, right? So we found and we believe that there were quite a few people who claimed to have been abused that weren't. But outside of that, where you have normal court processes, I do believe that we're able to get to the bottom of it. The last case I tried was for a man who was about 55. He had been sexually abused while he was between age 13 and 18. He was in a psychiatric center for children in New York. He had been born to an crack-addicted mom and so forth. And it was through documents that we received from the state of New York, which gave us the evidence we needed to show that the state of New York knew what was going on with him and that he had indeed been abused. But I appreciate the question. Yeah.
Have all the Epstein papers been released?
No.
I was under the impression that 2 months ago that President Trump said to release everything.
Right.
So why haven't they been released?
Of course, I can't speak to why people are doing what they're doing, but obviously the whole process has been ham-handed. It was a big gut punch to the victims because they were very hopeful because it seemed like this administration, because of who was taking over the FBI and the DOJ and the president, were going to finally disclose what went on and what has gone on. But then, the door's been shut. Now, the Comer Commission or committee is investigating now, and they seem to be making some headways. But it's a political mess, and so I can't tell you why it's not happening. But as I said, something's got to give because I don't think people are going to just let this pass.
Okay, question, thank you for Jason.
In regards to the statute of limitations, what pushback or argument is there to having no statute of limitations on this?
Right, so actually a number of states have gone that way. A number of states first extended the statute to age 45 or 55, and then as they started to see these cases, I think New York, California, maybe Minnesota have that. The pushback is simply sort of the same argument to any extension, is that the longer you go out, the more difficult it is to know for sure what really went on.
First of all, I really hope that we get the database bill signed and pushed through in January so that we know exactly what the problem is and how big it is in the state of Kansas. Second of all, what has changed in regards to victims, perpetrators, people involved in, is it a misdemeanor? Has it changed from a felony to a misdemeanor? Women who have been involved with prostitution or forced prostitution, where does that stand and how are our grooming laws in the state of Kansas?
Right. So most of the crimes involving child sex abuse are felonies. I'm not sure what our state says about charging the prostitutes. I don't know. But I'm interested, you mentioned a database. What database are you talking about?
Well, for the state of Kansas, how big is our problem?
Oh.
Is Wichita a huge problem? Is Hayes a huge problem? Is Kansas City a huge problem?
Right.
By creating a database, then we begin to know the size and the scope of what it is that's coming into our city or the state of Kansas,
Right.
because we are a thoroughfare.
Yeah, we are, definitely, yes.
Won't that bill then create a database so we know what is actually happening in our state?
I mean, the KBI does have a database for a lot of different crimes. I'm not familiar with anything that has something particular to do with sex trafficking, but that's something we might want to look into. Thank you.
Take that question back here.
They talk about the illegal immigrant children that have come in by hundreds of thousands. You know anything about that? Where are they? They talk about them being used for sex trafficking.
Right. I don't have any experience with in terms of my law practice with those victims. I saw, what was the name of the film that came out a couple years ago about that? Yeah, that was revealing. And I, intuitively, I think that's happening under everybody's nose. I was just told by someone here before I got up to this, there's suspected to be some sort of a farm near Garden City in which there's a lot of children who are being human trafficked in one fashion or another. But I don't have any personal experience with it.
Any question, Rebecca?
I'm involved with the ICTSOS, which we support women that are being trafficked. And I just had a meeting on Tuesday, and I took the flyer with your name and all and tried to get her to come to the executive director, but she assured me that the majority of the problem that we're having here in Kansas is Kansas born. It's not international people that are being trafficked. It's being trafficked by family members, neighbors, and their local people,
Yeah.
men and women. And we help them right over here off of Washington Street as far as the women getting back into their lives. So it's staggering that it's really homegrown.
Yeah, I just say that it's under our noses if we know what to look for, and because people really don't want to know about it, they look the other way. But groups like you, I think, are helping to inform people what to look for so that we can be more aware where it's going, where it's happening in the street, or in our neighbor's house.
Right here, Paul, got a question?
Yes, in regards to the state of Kansas and our school libraries, it's a known fact that there are school books that are normalizing touching and that kind of thing for young children. Who should be prosecuted for these books being in our libraries?
Right, so to the extent that they constitute child pornography, and I'm now litigating what constitutes child pornography in that Nirvana case that Jim mentioned. But essentially what we're arguing is that people think of pornography and they think of the real bad adult stuff. And it's true under our First Amendment that in order for that to be illegal, criminalized, it has to go beyond what they call community standards. It has to be really out there. So when you talk about child pornography or child sex abuse material with respect to children, people seem to think, oh, that's incorporating this extraordinarily difficult standard to meet. That's not true. The law is very clear that with respect to what we call where you're using children for this, it constitutes CSAM if it sexualizes the child. So if you have a 12-year-old girl and you show her partially nude on the beach and she's laying in a provocative way, if that were an adult woman, okay, whatever you think about it morally, that's not illegal, and you see those photos all over. But if it's a child, that is sexualizing a child and constitutes child pornography. So with respect to what you're talking about, if those images in that did that, then they could be prosecuted, I think. I'd also say with respect to libraries that the important thing is I don't know, not so much criminalizing it, but making sure that the boards that you elect or appoint, that they're on the people who run the libraries are not allowing what you're talking about to happen. And I think the avenue is less criminalizing that than working politically to get those boards properly constituted.
Last question. I want to go back here to State Representative Lita.
Just really quickly, I was just wondering, is there any path at all for holding the Department of Justice accountable for failing to hold accountable in the past?
Right, so...
Or even in the future,
right.
For future failures in these types of cases.
Yeah, so that's the gravamen of the case I mentioned that we filed, my firm filed in May, It says that the federal government failed abjectly to protect victims, and as a consequence of that failure, hundreds of girls and women were trafficked between 1996 and 2019. So that is, what the government's going to do in terms of discovery, we're still waiting. Are they going to, for instance, assert some sort of privilege, suggesting that it's if he were an asset, for instance, would they hide behind that and say we can't disclose information because it's protected from some sort of foreign privilege, foreign policy privilege? But that's the purpose of our lawsuit, and we'll see what happens and how they respond. They moved to change venues, and it's probably going down to Florida, but we really haven't gotten into the meat of that. Thank you for that question.
Just as a, before we give him a big round of applause, and I'd give him a standing ovation, before we do that, got to ask one question. Did Epstein kill himself?
I'll give you what I think happened, but anybody's guess. I think he wanted to commit suicide. He was a sex addict. He was used to, living in the lap of luxury, flying off here and there and getting whatever he wanted. And he was in a very difficult prison. I've been in that MDC, the Metropolitan Detention Center, because I've represented criminal defendants, and it's not a very pleasant place to be. So I think what happened is he bribed or paid the staff to look the other way and give him the opportunity to commit suicide. But who knows?
Let's give a big round of applause. Big round of applause.